Whatever, I think we can start. It's like 12:05.
Yes, we can start.
Okay. I am audible, perfectly audible to everyone. What I am audible to you?
Audible.
Sir.
Yes,
Good afternoon. Okay. Good afternoon, everyone. Welcome to this session of weekly knowledge series on indirect taxation by Team Anivesh. Today, I, Advocate Ayush Agarwal, and along with me, CA Gaurav Jha, who will be taking this session. The structure of the session is same as before. For the first half an hour, we will be discussing some important case laws for the past 1 week, and for the next half an hour, we will be taking the queries of all the participants. To start with, Gaurav, I'll start with the first case, and then you can take up the next. To start with,
Sure.
so in the past 1 week, I hope every GST practitioner or everybody here who keeps an interest in GST must have heard this Supreme Court judgment, which says that now the Supreme Court has sealed the fate of Section 16(2)(c) of CGST Act, which says that ITC to the recipient is allowed only when the supplier has paid the tax to the government either in cash or through utilization of input tax credit. So how the Supreme Court has sealed the fate of this judgment, whether the news in the market or the rumors, I must say, in the market is circulating are true, or is there any scope left wherein the Supreme Court, deliberate on this topic further, deep dive into this topic further, and may come up with some other ratio or judgment. So in the case of Bhandari scrap traders, the SLP was filed against the judgment of the Gujarat High Court, and that SLP was dismissed. Citation is 2026 VIL 69 SC, Bhandari scrap traders. So on what basis, we have to understand on what basis this SLP was dismissed. This SLP was not dismissed on the basis that it is not maintainable because of the amount involved, because of the jurisdiction involved. No. The Supreme Court categorically in this SLP, while dismissing it, wrote that I am reading the last paragraph of the judgment verbatim. In that view of the matter, the High Court was fully justified in holding that no grounds were made out to declare Section 16(2)(c) of the CGST Act as unconstitutional or read down the provisions thereof. We find ourselves in complete and respectful agreement with the views expressed by the High Court of Gujarat and affirm and uphold the impugned judgment. So whatever has been said by the Gujarat High Court has been upheld and affirmed by the Supreme Court by saying that there is no ground laid down by the petitioner to interfere with the judgment, as the High Court has considered everything. Now, as the High Court has considered all the grounds in it and has given a correct and an elaborated, detailed judgment. Now, one most important thing that the Supreme Court, the Honorable Supreme Court, noted in this judgment is that they took note of the judgment of the Tripura High Court in the case of Sahil Enterprises, and they write that we are informed that a special leave petition has been entertained in relation to the decision of the Tripura High Court in case of Sahil Enterprises versus Union of India. We find from the judgment passed by the High Court of Tripura that the exercise undertaken by the High Court of Gujarat in the judgment presenting the challenge.
ये भी है, ये क्यों है ऐसा क्यों है?
Okay, I have so muted. Was not undertaken by it. So the Supreme Court in this judgment has also mentioned about the judgment of the Tripura High Court in the case of Sahil Enterprises, which read down the provisions of Section 16(2)(c) and said that whatever the exercise has been taken in the High Court in the decision given by the High Court of Gujarat, that exercise has not been taken, has been done in the decision given by the High Court of Tripura. Therefore, they both are distinguishable, and therefore, even if the SLP against that Tripura High Court judgment has been entertained by the Supreme Court, they distinguished it and said that we are not inclined to interfere with this judgment. Secondly, they said that the Gujarat High Court in this judgment has very well laid down the detailed analysis from paragraph 42, and especially the scheme of input tax regime is set out in paragraph 56. They said that you cannot draw a parity between the Delhi VAT Act and the GST Act as enforced in present scenarios, because a distinction has been clearly drawn by the Gujarat High Court in paragraph 56 of its judgment. Hence, again, that Tripura judgment or the judgments laid down or the judgments came under the Delhi VAT Act are not applicable, such as on-quest merchandising, Shanti Kiran, Arise India, that was subsequently affirmed in Supreme Court. They all are not applicable in the they all are not applicable in the present case. Now, it's to understand that what is the issue that is being going on, or whether this High Court judgment of Gujarat High Court judgment, wherein in the case of Maruti Enterprises, wherein the 16(2)(c) was held constitutional, and also it was not read down by the Honorable High Court, and then now this judgment getting subsequently affirmed, SLP getting dismissed. We need to draw a distinction between the ratio laid down by the High Court of Tripura and the High Court of Gujarat, and then come to a conclusion that how the future course of litigation should be taken care of on the basis of these judgments, especially when the Supreme Court has ruled completely against us. See, when I talk about Sahil Enterprises versus Union of India, High Court of Tripura High Court, they also said that 16(2)(c) is constitutional. It is not unconstitutional. They clearly said that. But they read down the provision on the basis of that you cannot expect the recipient to do impossible tasks as such. They said that you have the power to check whether the supplier is registered or not, but you do not have the capability, you do not have any means to check whether he has filed the returns or not, whether the taxes has been paid to the government or not. Once this is not in your hands, you cannot be expected to go beyond it and check whether the taxes have been paid. And therefore, on that basis, 16(2)(c) was read. One more ratio that was laid down, that was there in the Tripura High Court judgment, was that if you deny the ITC to the recipient, then it would lead to double taxation. Double taxation as in, first in the hands of the supplier who has supplied those goods, and secondly, in the hands of recipient by denying him the ITC of the legitimate purchases. So, at the end, the High Court said that wherever there is a bona fide in the transactions, that whenever there is no collusion, connivance between the purchaser and the recipient, Section 16(2)(c) should be read down, and ITC to the recipient should not be denied merely on the basis because the taxes has not been paid to the government. Now, when I come to the judgment of the Gujarat High Court, how Gujarat High Court dealt with these two specific ratio of the Tripura High Court, I'll just discuss that only. That it is not that Gujarat High Court specifically discuss Sahil Enterprises, but these arguments were taken by the petitioner in that judgment as well, in that case as well. Now, how this High Court dealt with these logics of the Tripura High Court. The first is that how can you expect a recipient to check on the compliances of the purchaser when there are no means to check it? So how can you impose certain restrictions? How can you impose certain conditions on your supplier on which you do not have any control? See, in this matter, the High Court of Gujarat, in the case of Maruti Enterprises, specifically read that there can be a clause in the agreement, an indemnity clause. I'll just read it to you for the benefit of everyone. Just a second. Yes. So I'm reading para 76 of the judgment. The petitioners have heavily placed reliance on the maxim lex non cogit ad impossibilia. That is, you cannot expect someone to perform an impossible task, which means that law does not compel a man to do what he cannot possibly perform, is closely connected to the maxim impotentia exequas legem, which means a disability that makes it impossible to obey the law that can be excused and can be excused. However, the scheme of GST regime does not strictly attack the intent of the maxim. As previously held by us, the provisions of Section 41 of the CGST Act, read with Rule 37A of the CGST rules, recognizes that the purchaser are not unfairly penalized for the supplier's default. It is true that the purchasers cannot compel the supplier to deposit the tax with the government, thereby seek strict compliance of the provision to Section 16(2)(c), but simultaneously they can avoid the circumstances by due care and caution. The GST regime operates on the contract or agreement between two parties. While entering into an agreement, a purchaser can ensure that there is a clause that takes care of the lacuna and holds the supplier liable to indemnify the purchaser if the said purchasing dealer suffers a loss due to the default by the supplier to remit to the government the tax collected from the purchaser. Such clauses can be made part of the agreements covering such situations. So just this is the para, a specific para that I just read for the benefit of the members over here. Now, to understand it further, to deep dive it into further, what this para says is that as the Supreme High Court in this case discussed above, that they have Section 41, Section 42, and then read with Rule 37A. Now, what they have discussed above is that as per Section 41 subsection 2, as and when the supplier pays the tax, the recipient can claim credit in terms of Rule 37A, wherein there is no time limit again for reavailment of taking the credit. This is what the scheme of this, I'll say the scheme of the judgment has been of the Gujarat High Court, that the credit to the recipient is allowed as and when the supplier pays the tax in terms of Rule 37A, and there is no time limit for availing such credit. Now, it says that when you talk about the strict compliances with the purchaser, that how can you control it? It says that you can have an agreement, a clause in an agreement wherein the purchaser must indemnify the recipient that if it defaults in the payment of taxes to the government, it will indemnify the loss of ITC to the recipient. See, according to me, the High Court of Gujarat has gone beyond and, has laid down a ratio or has imposed another condition on the recipient or on this business, that you should have one agreement, one clause in an agreement to which indemnifies you against the loss of ITC in case of default by the purchaser. See, High Courts cannot direct as such. They have to discuss the law, interpret the law, and give the directions. Secondly, when the High Court has said that Rule 37A allows a reavailment of credit on the payment made by the purchaser, I would like to specifically point out Section 17(5)(I), I think, which talks about when the tax has been paid under Section 74, no credit of it shall be allowed. So what if the tax has been paid later on after 5 years, or as and when the notice of the department is received and the tax has been paid under section 74? So if the tax has been paid under section 74, so how you can the recipient can avail the credit of it? According to me, there are many things that has to be discussed. The Tripura High Court judgment has been again referred to the Supreme Court. The SLP has been admitted in that case. Now, what the Supreme Court decides in that case, whether they follows Bhandari scrap traders and say that the Gujarat High Court has clearly laid down the law and Bhandari scrap traders has accepted the law, so that SLP again will now being admitted will be decided on that basis only, or there will be a discussion on merits again on it, that we will have to see. But for the time being, I must say that Supreme Court has said that 16(2)(c) is not unconstitutional. 16(2)(c) cannot be read down, and it has to be followed by spirit and law. Whatever it is, you have to follow. What are your views on it?
Yes, it is. Now it become very difficult for the buyer who are waiting for the order of the Supreme Court, that when the Supreme Court might make it unconstitutional, or there will be some kind of benefit, or either it will be for a particular time period, but the court has clearly mentioned that it is unconstitutional. Now the buyer has to be very careful while buying from any person, any supplier, who even if you put in the agreement, it is not possible to trace on time. So when you buy from any buyer, initially they are okay, their registration is valid, everything is okay. Once the department investigate that person, who is allegedly the fraudulent kind of taxpayer, once the department find that the taxpayer is doing wrong things, after 3 or 4 or 5 year, department put that taxpayer under the court or under the bar that you are not existent taxpayer, your registration will be cancelled from back date. So it can be verified, and it is very difficult for the buyer. But yes, till I think still now there is no support for the buyer, and it is totally against the buyer who is buying genuinely from the supplier. So you have to totally discuss the thing. Now we can move for the next page. Yes.
Yes, please. Gaurav, are you saying something?
Okay. No.
Yeah, take up, sorry, I was thinking that you are taking up the. Please take up the next.
Okay. Okay. So should I take
Yes,
next case law?
please,
Yes.
please.
So I have also taken 2, 3 case law, important case law, which I find during the last week. And one of the first case I have taken is Miss Ayaz Traders versus Commissioner of State, and it is related to Hyderabad. Citation is 2026 VL 652 UTR. So in this case law, department has taken the concern regarding the service of notice. So what was the basic fact of the case? The taxpayer registration has been cancelled in 2021, and after that, so-called notice has been issued to the taxpayer, and the taxpayer were not aware because their registration has been cancelled, so they were not regularly logging to their portal. Now the department has issued notice against that cancelled registration for the preceding financial year, preceding tax period, and there were so-called notice, and after that the taxpayer has not complied, and the department has passed the order against them. Then they appear before the High Court, with the fact that when my registration has been cancelled, I was not regularly logging to the portal. So whether it will be deemed or it will be considered as the service of the notice. So for the service of the notice, section 169 of the CGST Act, it is clearly mentioned there that there are not a single means to serve the notice. There are so many means, and there must be a effective service of the notice. It should not be like that. You have uploaded on the portal whether the taxpayer has been shown or not, whether it has been communicated or not. The section 169 clearly provides three, four means. If you read section 169 of the CGST Act, it says that in under clause A, it says that the direct tender, whether you can, the department can send the notice through registered post or speed post, or they may communicate through mail address, or they may upload on the portal, or they may publish on the in the newspaper. Once the registration has been cancelled, then the department can't assume, and even the High Court has also specified that once the registration has been cancelled, then department must also consider that the taxpayer might not have been actively looking on the portal. So in that case, the other means should also be employed, but the department has not had not made any kind of effort to cross check or even verify whether the notice has been served or not, and the case has been dismissed by the High Court, mentioning the same thing, that the department should taken care that whether the effective communication has been made or not. So for us, it is very whether it the case is related to the cancelled taxpayer. But in normal scenario also, we must have to make a proper evidence that whether the notice has been received. If you are not logging portal regularly and department has issued the notice on the portal and even on the mail, but you are not aware about that, whether you don't have the access of the same, if you can prove it, then these kind of judgment will support to the taxpayer that once the notice has not effectively received by the taxpayer, the department cannot proceed against the taxpayer. So this is the first case that I have taken.
Right.
Now the next case is related to GST. It is a kind of procedural things which I have covered here, and the case is very interesting. The case is Tajbar Rawat V partner versus state of versus GST 80 Ghaziabad bench. So it is related to Ghaziabad bench. In this case, what has happened that the taxpayer has filed an appeal before the GST. We have seen that the portal is having so many kind of difficulties, and the department has also made some kind of order, presidential order, that if there are basic kind of mistake, the department or the GST should consider that thing and don't consider that much strictly while in the initial phase of the filing before the GST. In this case, what has happened, the taxpayer has filed the appeal before the GST. Now the registry has power to scrutinize the same. And once they scrutinize, if they find any kind of defects there, they intimate to the taxpayer, and the taxpayer has to comply with it. Either they have to correct it. Now the Rule 24 of the GST rules provide the power for the scrutiny of the appeals. So department has scrutinized the appeal and find some kind of defects there. They have intimated to the taxpayer 2-3 times, but the taxpayer has not made any kind of response. Now the main things happen that whether GST should wait for more time, further provide the chance, or they should have take the action. So in this case, GST 80 has Rule 10, which provide the office or the registry the power to take action, and even they have inherent power which deals that what kind of requirement is there, on the basis of that they may pass the order. So in this case, what has happened, the department has issued the defects. It means GST 80 has issued the defect. The taxpayer has not complied with it. Now the GST 80 has to take action against. In such case, the GST 80 has taken the action and make the dismissal of the case. And dismissal, and they have written that dismissal for non-prosecution. Non-prosecution means the department has provided so many chance to the taxpayer, but taxpayer is not responding against the same, and the department has rejected the appeal. And they have quoted two maxims. The one maxim is very important, which says that the law assists those who are vigilant, not those who sleep over the rights used to justify penalizing the appellant in action. Means the department says that if you are not vigilant, then department can't do anything. We have provided you the so much opportunity, but you have not responded on time. Hence, the case has been dismissed. So this is the second case. Here we must have to take care that once we have filed the appeal or any kind of submission before the department, we must regularly check the whether any kind of communication from there. Specifically in the case of GST, registry has specific power. Once you file the appeal before the GST, they might ask for correction. They might have, if they find the defects, they ask you to submit the response against them. If you will not submit the response and you ignore it, then the department may reject your case. So we must have very careful while these kind of defects or the notice are coming. We must have to submit the reply on time. So this was the second case. Any input from your side?
No, correct. I mean, ignorance cannot be excused every time when the department is issuing notices for defect order and anything that has been issued, it has defect has to be cured, and that notice has to be properly replied to first of all. So
Okay.
saying that these ignorance cannot be excused by the GST, and I think this judgment is fair enough.
Yes. And one more judgment that I have covered is Running Global as Auto Spring Private Limited versus Commissioner of GST, High Court of Uttarakhand. The citation is 2026 VIL 654 UTR. In this case, we have faced so many times that the department is allowing us to submit the reply up within 1 month, and they are saying to appear before us within 7 days, within 5 days, means before the due date of the reply. So that case has been taken by the High Court of the Uttarakhand. In this case, the taxpayer has the department has issued the notice before the taxpayer on 21st December 2023. They have asked for the personal hearing on 29 December, and they have allowed time to submit the reply by 21st January 2024. Means they have to appear before the submission of reply, and this kind of notice are coming regularly by the various department. So this case has reached before the court, and they have appeared before the department. They have taken 2-3 provision under the GST Act, which says that section 73 or 74, which is clearly says that the department has the power to investigate in the matter whether it is fraudulent or not fraudulent, and they may ask for the response or submission. Now the next section is very important here, the section 75(4). Section 75(4) talks about the providing the opportunity to appear personally, means personal hearing. So if department is taking any adverse action, before taking any adverse action, section 75(4) mandate that the department must provide a personal hearing. Either the taxpayer may ask for the personal hearing, or if the department is taking action adverse, then they have to provide the personal hearing. Now the department is doing that before before the due date of the submission of reply, they are asking for the personal hearing. So the taxpayer has filed the case against this kind of scenario, and section 75(5) also talks about the taxable person to seek the adjournment. So now these three provisions cumulatively provide the taxpayer right to submit reply, answer the question or the point that has been taken by the department, and if in support of the reply, if they need, then they will appear for the personal hearing. Here in this case, in so many cases, department asks for the personal hearing before the due date of the reply. So court has taken very seriously this, and they said that once the reply has been until the reply will get submitted, how the personal hearing will be validate the purpose of the law, which clearly says that there must be a personal hearing. So department has also quoted clearly that if a statute prescribe a manner, it must be done in that manner only. You can't just make the documentation that we have provided the personal hearing, but even that there are no means that once the reply has no, even the reply has not submitted and you have mentioned for the personal hearing, they appear before the court and the court has rejected. So it is very useful in case where the personal hearing has been scheduled before the date of the reply. And we are facing this kind of issue in so many cases. So this was the third case.
There are one
I
or two,
you reply.
I think there are one or two high court judgments prior to this judgment as well. I don't know whether they are being referred in this or not, but
Yes.
same judgment has been issued by another high court that, I mean, one or two high courts that date of personal, and obviously it is on the basis of principles of natural justice, logically, whatever you can say, how can the date of personal hearing be date before the date of the due date of reply? How can you be ready with the
Yeah.
reply on the date of personal hearing if I do not have the reply ready with me? I mean, so all well and said, these are the procedural, I think these are the procedural lapses going on that were going on in the initial phases of GST, wherein the department was also not sure about the procedures, practices, litigations, etc. But from
Yeah.
2022, basically, if I talk about from 2022, I have seen that the department has also streamlined its procedures of issuing the notices and everything, and now these type of technical errors are not there. If I'm not wrong, because from 2022, I'm talking specifically only. These type of procedural errors are not there. In the initial phases of GST, obviously, all these problems were there. But right now, the AI generated notices are still there, which are being challenged by the High Court, which are challenged in the High Court, AI generated notices. And the main problem that is arising nowadays is in the last meeting also, I think I discussed this one judgment about this, that the order in original being prepared with the help of chat gpt, that is all right. You can prepare with whatever help you may want, as long as it is correct and legal. But at the end, the chat gpt is, at the end of every answer, the chat gpt suggests something that, do you want me to do this as well, do this as well, do this as well? I can do this kind of suggestion is given by chat gpt or any other AI whatsoever. So what the department did was they copy posted that also in the order in original, and then given the order in original as an annexure to the main DRC 07. So these type of
Yeah.
procedural errors are being still made by the department, and these are the human errors as such. I don't know whether how will they be dealt with, but what I'm talking about is that these judgments, I mean, giving personal hearing date before the date of due date of reply, are now being streamlined to much extent.
Yes.
So next, one more judgment I'll discuss quickly, and then we can move on to the query session then. This is in the case of Raj Machine 2's Madras High Court. Why I considered this important is Section 7310 and Section 73.2 that we will discuss while discussing this judgment is. Section 7310 gives a timeline for the issuance of an order. It does not give any timeline for the issuance of a show cause notice. It says that an order should be passed within 3 years from the due date of the filing of annual return. And what Section 73.2 says is that a notice should be issued before 3 months from the due date of the issuance of an order. So effectively, if I say, all in all, I can say, if I take out a meaning, legal interpretation of whatever meaning is, that there should be a gap of at least 3 months between a show cause notice and an order. And order should be passed within the due date of whatever is given in the Section 7310, that is within 3 years. Now, just to give an example I'm giving, an order which is passed on 31st December 2025, which is passed on 31st December 2025, and say it is an order of, I am saying 23-24, financial year 23-24 order passed on 31st December 25. That is very well within the sufficient timeline. 23-24, 31st December 25. Now, the show cause notice was issued on say 31st October 2025. So 31st October 25 show cause notice was issued, and within 2 months that is 31st December 25, an order was issued. And mind you, the period involved is financial year 23-24. So order is issued very well in the timelines, within the timelines. SCN is can be said issued within the timelines, but there is not a gap of 3 months between the issuance of a show cause notice and the issuance of an order. Can I challenge that show cause notice or that show cause notice that because it is not before 3 months from the date of issuance of order, therefore it should be set aside. So this is the whole case in the Raj Machine Tools Madras High Court, that though the order is passed within the timelines, but the show cause, the time gap between the show cause notice and the order is not 3 months. So now what the department, the High Court in this case said that 3 months period, first of all, is not mandatory. Why the 3 months period has been given is to give sufficient time and sufficient opportunity to the taxpayer to furnish a reply to a show cause notice. However, if it is clearly established from the facts of the case that a sufficient time was given to the taxpayer with sufficient opportunities to represent its case before the department, then even if there is not a gap of 3 months between the date of a show cause notice and the date of an order, you cannot say that a show cause notice is invalid. That was particularly being held in this case, clearly said that section 73(2) must be interpreted in light of 73(10), which prescribes 3-year limitation period for issuance of order from the date of annual return. The provision in section 73 requiring show cause notice to be issued at least 3 months prior to time limit specified in 73(10) is intended to ensure that SCN is issued not less than 3 months before the limitation period or adjudication expires. The object and purpose is to prevent proper officer from issuing show cause notice close to the expiry of limitation deadline and thereby hastily concluding the adjudication without reasonable opportunity to the taxpayer. However, the provision does not mandate a 3-month interval between a issuance of show cause notice and issuance of assessment order. Even if the SCN was issued more than 3 months before a limitation deadline, the assessment order can be issued after reasonable interval without strict compliance of 3 months period between SCN and order. So clearly said that 3 months gap only being given to do not, so that the tax department does not conclude the assessments hastily, should not issue the show cause notice at the date of deadline only during the and sufficient time should be given to represent the case. However, it is not strictly given that there should be a gap of 3 months between a show cause notice and an order. Second issue in this case was that there was 2 separate orders was issued in this case for the same period, wherein the one order treated the same supplies as exempt supplies and the other order treated the same supplies as taxable supplies. So 2 separate orders for the same period, one treating the supplies as taxable, another treating the same supplies as exempt. So in the Madras High Court clearly held that this cannot be done. Both the orders are set aside, and then the matter was remanded back again for fresh adjudication to determine that whether the supplies are either taxable or exempt. They cannot be both. They cannot be, if not so. On that basis, the decision was being given, but the important part to discuss was that whether there should be a mandatory gap of 3 months between a show cause notice or and an order or not, and that has been said by the Madras High Court that the time limit is not mandatory; it is only discretionary, but a sufficient opportunity should be given.
Yes, I think
Yes.
in this case, I will put one line that if this will be mandate that there will be 3 month time gap between the notice and the order. So left the situation of the time barring per month or the time barring year. In a general scenario, I think 80 to 90% order of the department is generally concluding after the once notice has been issued. They provide 30 days time limit, and after 30 days, they generally take 1 or 2 weeks and they pass the order. So more than 60-70% case will come in this
Right, right.
situation that their order will not be valid. So they have also considered and taken back of the mind that if I will say this, then there will be so many cases before the court that
Hmm.
this order has been passed only after 20 day, 30 day, only after the 40 day, 50 day, less than the 3 month gap. So that's why I think there might be one reason of that also. And but there should be a clear gap of 3 months so that the education, because you have to provide personal hearing as well, you have to provide opportunity for adjournment also. So
Right.
in generally at the end of the limitation period, department takes the order in haste, and these kind.
Gaurav, we lost you. Sorry. Hello. Am I audible to others? I think we have lost Gaurav, or is it a network error from my side?
Yeah,
Yes,
you are clear.
audible.
You are audible.
Okay. I think then some issues from Gaurav's end only. Uh, okay, we can take up the queries now. If any participant has any query, they can either raise their hand, unmute themselves, or they can write it in the chat box. Meanwhile, I'm taking this one query. Uh, can we ask for PH after the due date for reply if as per SC and PH is before reply due date? Surely, yes, sir. We can anyway ask for the adjournment or condonation, anything we can ask for. Majorly adjournment is said in this case, as seeked in this case, and we can ask that say that the reply date is after, sorry, the PS date is before the date of reply date. Therefore, kindly set any date which is after the due date of the reply, and I think the department must oblige to the same.
Yes.
Right. Any other query that anybody would like to discuss?
So I think right now there is no query pending. Till I like to ask one question from you that
Hmm.
in 16(2)(c) case, is
Hmm.
there any way forward further, or is there any more case laws pending which we should look forward, or now or from your point of view it is settled? What's your take?
See, for me, this Sahil Enterprises judgment, which has that the Supreme Court has filed SLP, sorry, department has filed SLP in the Supreme Court and has been entertained. We should wait for that judgment.
Yes.
And then after this also, there must be some review petitions that will be filed. The review petition against this judgment will again be filed before the Supreme Court again to see and to at least accept the SLP and then discuss it, and then you may give your judgment on it, not to merely reject the SLP saying that the whatever the decision has been taken is correct. And so review petition will be filed. That one judgment is still pending of the Supreme Court.
Because
But
there are so many constitutional grounds also there, which
correct.
clearly has not been taken by the Gujarat High Court. Like,
See, yes.
yes, yes, your take.
Yes, yes, yes. What grounds you were saying?
Like that, law can't impose anything that is not imposed. So this is the very basic constitutional right for the any person who bought the goods, who have paid the tax before to the respected or the buyer from whom they have supplier from whom they have made the purchase. They have made the payment of the tax. Now you are not allowing them input tax credit just because of the fault of the others.
Correct. See, correct. See, on that basis, I'm totally with you, Gaurav. But what
Yeah.
what I'm trying to say here is what Gujarat High Court said for this argument is specifically two things. The first is they said that that you should have that clause in your agreement wherein the supplier should indemnify the recipient, and that if there is any default in paying the taxes, then that purchasing dealer should be indemnified. Purchasing dealer should be indemnified by the seller. Second, what they said is that time and again courts have held that ITC is not a constitutional right. ITC is not a vested right.
Mm.
ITC is a statutory right. And this is the line that the judgment only that I am,
Yes.
telling,
Yes.
discussing here. So once it is a statutory right, all the conditions as mentioned in the statute should be satisfied. One of those conditions is 16(2)(c) that the taxes should be paid by the supplier. So if that condition is not satisfied, then you do not have any statutory right over that ITC to claim it. Now, when I say that condition in itself is onerous,
Yes.
beyond the breach, lex notch cause it impossible, yeah, that is all correct. But Gujarat High Court, I think, is correct reasoning or incorrect reasoning, dealt with these arguments and negated all the arguments and held that 16(2)(c) is. I mean, do not say that it is unconstitutional, but they can always read down the provision and let's see. For now, for the future course of litigation, that I'll suggest is
Yes.
pay the taxes. If there is any such cases, pay the taxes under dispute, because Supreme Court right now is clear that 16(2)(c) is not unconstitutional, cannot be read down. So pay the taxes under dispute, so as to avoid this interest liability. Penalty liability can obviously be defended on the basis of that there has been always a confusion in the industry, and
Yeah.
then since many judgments of the Supreme Court are coming on this basis, so it clearly reflects that there has been an industry-wide confusion. Therefore, the penalty on it should not be levied.
So the last hope is Sahil Enterprises judgment.
We can
If
say yes.
yes, if anything favorable is coming, then okay. Otherwise, we must have to be very careful in these kind of cases.
Correct.
सत श्री अकाल। मैं भी मोदी हूँ। जी हाँ, मैं भी मोदी हूँ, मैं भी मोदी हूँ।
Sitaram. So, any other query that anybody would like to ask, or otherwise we can wrap up the session, Gaurav?
Yes, yes.
Okay, I think there are no queries.
Yes, Govinda here.
Yeah, Govinda ji, please.
Yeah, I have no practical case, just for knowledge purpose. If GST, if I not able to generate a token before 31st July, then any other way?
Sir, you have this condonation period of 3 months.
Okay, then
You can file the appeal. You can with the condonation application, your condonation ground should be very strong that why you could not file the appeal. And I mean, in the starting, the bench should be liberal enough to or lenient enough to entertain all such condonation applications, and then will allow the appeal as well.
okay. And if I'm not wrong, due date of order 31st May. Reply for this, if I'm not wrong.
31st.
Sir, no, 30th April, no, May, June, July. Yeah.
May.
Sorry, 31st May is for the government. For the taxpayers to file the appeal, the last date of order is 30th April. Then you have to file till May, June, July. Yes, 30th April, because earlier it was 31st March. Now it is 30th April. Gaurav, if I'm correct.
I think he is asking about his order on date of 31st May. Then what will be the due date?
Yes.
No,
Okay.
Maybe due date of 31st July. If I receive order before 30th April or May.
So 30th April, sir.
30th April. Okay. And then after that receive.
Because sir, see, you have to consider 3 months. See, from 1st of May, you have to consider 3 months. Then we from 1st of May, 3 months will expire in August only, June, July, August. I mean, 31st July can say a week. But yes, 30 the notification stops till 30th April. From that, you have 3 months, proper 3 months to file the to file the appeal.
Okay, as you can. Thank you so much.
Okay, Govind. Okay. Thank you, everyone. Thank you for attending the session. Thank you, Gaurav. Let's hope to meet next time as well with large numbers.